There is an ever-growing case backlog in today's U.S. immigration courts, but can AI help the process without harming due process rights? Welcome to Clarity on Tech, a podcast powered by the Thomson Reuters Institute. I'm Zach Warren, the Institute's Technology and Innovation Insights lead. In each episode, we dive deep into the future of the legal, corporate, tax accounting and audit, and government communities. On today's episode, we discuss the convergence of artificial intelligence and the United States immigration court system, at a time when immigration courts need more aid than ever before. Today, TRI's Rabihah Butler dives deep with two former immigration judges, Florence Chamberlin of California and Anam Petit of Virginia, to discuss the challenges facing today's immigration courts, where technology can help with handling immigration cases, and what type of systemic reform could bring court efficiency.
My name is Rabihah Butler, and today we will address a subject of significant relevance and complexity: the convergence of AI and the United States immigration court system. This is an issue that must receive open and thoughtful consideration. We understand that there is a ton going on in the area, and I think it's very important that we begin to discuss it. As technology continues to transform the industry at as technology continues to transform industries at an unprecedented pace, it is essential to assess how many AI impacts our legal systems. The implications are particularly profound when considering areas of critical as due process and human rights. It is imperative for the legal profession and society as a whole to carefully evaluate whether AI can support immigration judges and the courts without undermining the core values of fairness and justice. To help us navigate such an important discussion, we are privileged to have Judge Florence Chamberlin and Judge Anam Petit. Both guests possess extensive experience within immigration and the judiciary and bring valuable insights from their years of experience. They will begin by providing us some foundational information, especially considering the operations of the administrative courts, and we'll begin examining distinct challenges that present an immigration court in that context. Our discussion will address some urgent issues, such as the significant case backlog and other complexities within inherent in the administrative and immigration law fields. We will also consider potential solutions, including the integration of technology and AI to enhance certain case management systems. I invite you to engage with us as I invite you to engage with us in this comprehensive conversation with the hope that it improves the informative and beneficial to all participants. Welcome, judges.
Thank you.
Thank you. Thank you for having us.
So I don't know who I'll start with, but can you guys tell us what drew you into immigration and to become an immigration judge?
Sure, I'll start us off. I fell into immigration in law school. I did my 1L summer internship at the Immigration Law Clinic, and I never really looked back. But even on a more personal level, I am an immigrant. I moved to this country when I was in elementary school. I naturalized when I was in law school. And so it had a real life effect on my life as well as my family's. And I never really looked back. I mean, I stayed in immigration from law school onwards. I've always loved the dynamic nature of the field. You can do litigation, you can do transactional work, you can do removal defense, you can do employment based immigration. It's kind of whatever you make of it. And then, of course, what I always loved and what kind of kept me going in a difficult field was the gratification that I received in helping immigrants and families and learning about the law in a way that could ensure just outcomes, especially when I was on the bench. So for me, it's kind of a combination of personal, but also just falling into it.
Yes, my trajectory is similar in that I also come from an immigrant family. My mother was from Cuba, and my father is a son of immigrants from Russia and Poland. And I always had an interest in other countries, political histories, people generally, their life stories. And it was a natural fit with immigration law. Immigration law was an area in law school that I realized would allow me to work with families, but it also appealed to me because I could work with business people and entrepreneurs, just like my parents, and brilliant innovators in the tech field. immigration law was an area that just, it is very, it provides many opportunities to engage in these different areas, and all of them were of interest to me. And transitioning to the court was a natural fit for having worked in the field for more than 20 years in private practice with companies and with in the nonprofit sector. So
Judge Petit, could you provide our listeners with a more foundational understanding of how administrative court system operates and its role within the broader judicial framework?
Sure. And I'll focus my response on the immigration court system, since that's really what we're interested in discussing today. So, what a lot of people don't realize is that despite the name, it being an immigration court system, it's not the same type of judiciary as we see in a lot of other contexts within our government. So, we are part of the Department of Justice. The immigration court system is known as the Executive Office for Immigration Review, and that structure actually is a big source of a lot of its flaws, many of which are being capitalized on these days with this administration. The immigration court doesn't have the same type of independence that a lot of other judiciaries have. We're not an Article 1 or an Article 3 court, although there is a strong push for advocates on making it one of those constitutional courts. But it is part of the Department of Justice. It reports directly to the Attorney General of the United States. So it is quite vulnerable to the political whims of whoever's in the White House.
immigration courts handle civil removal proceedings, not criminal prosecutions, but the stakes often feel just as high because we're dealing with liberty, family unity, safety from persecution. There's no right to appointed counsel in an immigration proceeding, there is no jury, and there's very limited discovery. Things also happen at a very rapid pace once the person is, in their court proceeding. Um, the Department of Homeland Security acts as the prosecuting agency. Their attorneys are referred to as assistant chief counsels, and the immigrants are referred to as the respondents. The immigration judge will preside over the proceeding. In the immigration context, if there is an appeal, it goes to the appellate body known as the Board of Immigration Appeals, and then further review can go to the Federal Circuit Courts of Appeals. But the process is very narrow and deferential to the board determinations. And then, in essence, it's a system where it appears as if a court exists, but we do not have, or the court does not have, the independence or procedural protections that would define the typical court.
That's really interesting. Even having practiced law, I really didn't know that it wasn't an Article 1 or an Article 3 court. I guess I didn't pay enough attention. So, what would a typical day look like in an immigration court?
So it's very busy. I feel like that's one of the best words to describe the overall day. So immigration judges' days can differ based on their dockets. There's a detained docket and there's a non-detained docket. I had a non-detained docket, which meant that I was presiding over cases of respondents who were not in ICE custody. Our days are a mix, but they're generally filled with hearings and trials. They can be preliminary hearings, known as master calendar hearings, or they can be trials, which are known as individual calendar hearings. Individual calendar hearings are typically quite long to ensure due process, and given the complexity of these cases, a judge really needs to take time to meaningfully hear the evidence and issue an informed decision. But then, even outside of the court and the courtroom, we just have so much to do. We don't have a ton of support, legal or administrative. So, judges are really in charge of a lot of docket management. We have to confer with our staff. We have to issue written decisions. We have to adjudicate motions. We have to research cases and prepare our cases for the next day or the next week, depending on how prepared you are. Uh, but it's a very busy day. I was constantly working through my lunch, getting in early, working late, just so that I could be as thoughtful and prepared for each case and decision that I had to make.
So, let's kind of move forward a little bit to some of the current challenges. Now, I've talked to a lot of judges about a lot of different things, and one of the things that we notice is that your experience from the bench gives you a unique view on what the difficulties and challenges are. So, based on your experience at the bench, what would you identify as the most pressing pain point or systemic challenge that currently faces immigration courts?
So I kind of previewed it with one of my last answers, but it's really just the lack of independence at the immigration courts. In my opinion, that's one of the biggest challenges to the system. And Judge Chamberlin, I'll be interested to hear if you agree. But it's just the fact that we're nestled in DOJ and that we are so malleable to who's in the White House and who the Attorney General is. It's been this way for decades. We've always kind of had legal whiplash and we've seen changes in the jurisprudence of the court and how it's run. But this administration has kind of run away with it. And I think we can all kind of see that from the news and even just kind of having a general understanding of the platform is that there is this emphasis on immigration enforcement. And that has really affected the immigration court as well, that has typically been outside of that area of enforcement. And so that lack of independence has actually caused a lot of problems. It's just it pervades everything because it controls how our dockets are run, if we have case completions, whether there is an ICE presence at the court. This is all something that is affected by our lack of independence. And judges, we have a lot of discretion in our courtrooms, but we also don't have a lot of discretion to kind of manage our dockets the way that we want to do and to really put our foot down with the way that we believe things should be done, because we do have a boss at the end of the day, and it's the Attorney General.
I think you've captured it. I would agree. You've captured those challenges accurately, and I'm going to address. I do when I talk a little bit about the use of AI. I think having an independent judiciary for the immigration courts would really be a great solution, because we can implement tools that we think will be helpful in addressing some of the problems. So when we talk about AI, I think a little bit clearer why having more independent judiciary could be useful in this context and preserving the due process rights within the courts.
And
So
Florence, one thing I failed to mention was the backlog. Do you want to touch on that? Because I also think that will become relevant to the AI discussion.
yeah, I mean, the backlog, I believe, it's now more than 3 million cases, if not more. And I think that, um, you know, one thing that and I'll mention it later, but you have a large volume of cases, a large short amount of time to hear each case, and the numbers keep growing. And then we also have now a limited number of immigration judges. With the recent release of all the immigration judges, I think we had more than 700, and now we're down to in the 500s, to address this huge docket. I think my docket was approximately more than 5,000 cases, and my hearings were being set out until the year 2029. To give an example, so somebody who was coming into my court waiting for a hearing date would not be getting a hearing until 2029. And that was fairly true for, I think, for all of the judges who are currently on the bench. They're facing those challenges.
So you guys are talking about the backlog, and that's an insane level. But particularly within the immigration document, particularly within the immigration docket, it's been very well documented. From your perspective, what is the primary factor that's contributing to these delays?
So there's no question that there is a backlog, but why there is a backlog is a little bit of a tougher question. I mean, of course, the amount of people coming into the United States at the border is one factor. Many of them are seeking asylum and they're afraid of persecution, or they have already suffered some form of persecution or torture in their home country. But people come to the United States for a wide variety of reasons. Uh, but then and I don't want to be a broken record here, but the structural defects in the system also do contribute to the backlog, because judges don't have a lot of independence on how to manage our dockets, and because we have case completions, but there isn't enough of an emphasis on due process and giving us enough time to complete these cases in the way that the respondents deserve them to be treated, is a hardship. But then part of the backlog story is also just that respondents are entitled to due process under our Constitution. Every circuit court in this country has upheld that fundamental belief, and due process takes time. You can't rubber stamp cases and still ensure due process. You can't adjudicate a complex asylum case with emotion. You need to hear the story, you need to take the time to listen and to review the evidence, and then have time to issue a decision. And so that's part of the problem, is that these cases take time, and firing immigration judges who are qualified and have received extensive training is not the way to respond to the backlog. The backlog needs more judges. It doesn't need fewer judges.
So, to what extent does the complexity of administrative immigration law itself contribute to these delays and the other systematic challenges in addition to providing due process, specifically in different locations?
So, immigration law is extraordinarily complex. There's overlapping statutes, regulations, precedents, and it's been described as second to only tax law in its complexity. And a same case can produce different outcomes depending on the circuit law where you are, or even according to the individual judicial interpretation. And you know, and the demands of the court. Actually, Judge Petit was her court was in Annandale, and mine is in Concord, California. We have different resources. Mine was it wasn't a satellite court, but it's a smaller court. But the staffing levels may be very different. Our judicial law clerks, we had quite a few in my court, but the San Francisco court, for example, had more judges and fewer judicial clerks to assist them. So it's always sort of a balancing, but I think some of those complexities play into the delays and some of the issues that take place.
And just to put a point on that as well, Judge Chamberlin mentioned that she had over 5,000 case docket and was setting out trials in 2029. My docket was about half of that, and I was setting out trials for 2026. But my docket also had a lot of aged out juveniles. So just the nature of the docket is very different, and it really can have an effect on outcomes and how you run it. But then our support is kind of all over the place. I wouldn't be surprised, Judge Chamberlain, if you had the exact same amount of legal support that I did, despite having a docket that was 2x. So the court there are a lot of ways that it's run that are not really intuitive and aren't really tailored to maximum efficiency.
I think folks are sometimes surprised too to learn that we still have pretty outdated systems. Like paper filings, inconsistent access to interpreters, lack of staffing. You don't have, for example, a court reporter in your courtroom, or that you might have in a different setting. You have a staff person that they're amazing. We have incredible teamworks, and there's incredible staff that work together, but with limitations, right? And staffing resources. So those are things that maybe it's just the nature of government, but if immigration is a priority, those are things that could contribute to efficiencies, providing that support and strengthening the system rather than, I mean, those are things that are happening in other courts, federal courts, I think, and I think they should be equally provided to immigration courts.
So let's look forward a little bit and look towards the solutions. How do you envision artificial intelligence and other technological tools assisting in the case management, legal research, or even the decision making process as we're looking into the immigration courts?
Sure. I would like to address the promise of AI. We're working in a field that has huge volumes of demand as far as cases and information are concerned. AI is great in that context. law firms and lawyers, as well as the respondents coming before us, are looking for solutions, and they are already using and integrating artificial intelligence. So I think that innovative uses of artificial intelligence can be critical in also in ensuring access to justice when there's simply not enough licensed practitioners to meet the needs of the people coming into the courts. Federal court judges and bar associations and states are creating task force and already thinking critically and working on how to safely and productively integrate AI as a tool in the federal and state courts. So it is logical that the administrative and immigration courts would engage to look for ways that it could help address the challenges that Anam and I have just described previously. I'll focus on some of in the immigration court arena, but there are many areas of potential where AI is being productively considered, whether it is outside of the immigration court context, just whether it's researching, matching global migration patterns and labor needs with specific countries, or resolving access to justice opportunities for migrants on the move globally. I see unique solutions coming from the very brilliant tech entrepreneurs who have benefited from visas themselves in the United States, and I see contributions coming from them, and they have a deep understanding of the challenges inherent in the visa processing, in the administrative visa processing. But I'll say my observations are simply my own. I'm not an AI expert. I would say I'm more of a curious observer who has come to this topic with a deep commitment to instilling fairness in the administrative courts and looking for solutions to problems and looking for ways to strengthen one of the foundations in the critical court processes for so many people. I hear a lot of fear around the use of AI when I mention it to immigration judge colleagues or just in the context. And I prefer to be solution oriented and practical. I think sticking to what we've identified before, AI could be used for customized case preparation for immigration judges. AI could be used to assist in summarizing relevant information when judges prepare for hearings, particularly where judges have packed dockets and very little time to prepare. So, for example, we have master calendars, which are scheduling or calendar calls, and you may have up to 60 individuals appearing before you in one morning. Respondents must receive from the court critical statutory advisals during that process, and they are literally inundated with important and technical information that has to be translated into their languages. We have some tools in the courts available for categorizing aspects of cases for the judges who are preparing for these hearings, but they're not necessarily customizable. So I think each judge might have their own preference based on how they like to review each case before the hearing. And it can take hours of important preparation. AI could do some of AI could provide some incredibly nuanced support in this context if integrated properly. In terms of legal research and scheduling, immigration law, AI could be very effective in these areas. Immigration law is extraordinarily complicated, as I said, second to tax law, with constantly evolving regulations and circuit splits. AI could help the judges quickly identify relevant precedents, flag decisions, consider policy memos that we receive on a weekly basis sometimes. A judge could use AI to more efficiently coordinate their scheduling. A judge might also be able to use AI more efficiently to coordinate scheduling. Judge Petit mentioned, for example, that we don't have control necessarily over scheduling. In 2025, I was still reviewing some paper files, having to tab and number paper exhibits with a Sharpie and Post-its. AI can be used to do something as simple as putting cases a judge knows will require more time because of complex language issues or subject matter issues on particular days, and reserve space for matters that can be resolved quickly in other spaces. We do this essentially manually right now. It's just a skill. If you think about what cases you have, you try to schedule them efficiently based on what you know about your own case docket. But I think there's room for greater efficiency that AI can address. The critical distinction for AI use in the immigration courts is, especially if it's used in research, should be that the tool is it's used as a tool, as a research assistant, and not a replacement for a decision maker. Judges must exercise their independent judgment on credibility, discretionary relief, and they must constantly apply the law to the facts, and it must be done in a way that remains human centered. This is especially crucial in immigration cases where we're hearing persecution claims, issues affecting family separation, or whether someone will face torture if they're returned home. These types of decisions cannot be handed over to AI.
So it sounds like you've given us a lot of opportunities that AI can create, and we talked about using it as a tool, especially. And I've heard a lot of judges talk about that. But can you kind of give us an idea of what safeguards or considerations that we really need to put in place as we begin to integrate AI and those technologies in judicial proceedings that would allow us to ensure due process is taken into consideration?
Sure. On the bench, I have seen AI being used by attorneys and respondents in their document preparation filings, in their document filings and in their preparation for hearings. And I think, as far as the court is concerned, the EOIR issued a recent policy memo guidance in August of 2025. Essentially, there was no blanket prohibition on the use of AI in the courtroom, but there was a strong emphasis on attorney accountability for verifying that AI was not generating or hallucinating, and that there should be verification for AI generated citations and such. I think the EOIR in this policy memo sought to preserve judicial discretion, stating that nothing in that memo should limit an adjudicator's independent judgment, which is excellent. But the memo, I would say, focuses on the attorney's use of AI, and there is no real information about EOIR's own use of AI in the court systems, and that's a gap that I'll return to later. I think when we talk about safeguards and the use of AI technology, there are universal concerns, of course, with bias prevention. It's a challenge that every court system using AI is recognizes. AI systems learn from historical data, which can reflect past discrimination in the immigration courts. That's particularly important and concerning because I can give an example. Historical grant rates might vary dramatically by nationality, by judge, by time period. Enforcement priorities shift between various administrations. Data from different eras might be embedded in different policy approaches, and there should be safeguards such as testing, rigorous testing. So, for example, any AI tool must be tested for bias related to nationality, ethnicity, language, or other protected characteristics. Regular auditing comparing the AI outputs to the decisions should be considered, and there should be transparency about what data was used in various trainings. So, for an example, um, suppose there is an AI case management system that's trained on data from a period when there's been very high grant rates or grant rates that were at historic lows. The system might learn those patterns, and certain case types might move quickly and others might be deprioritized. So, I suppose, or for example, now we have different policies in place in 2025, but an AI might still be operating based on old patterns. It's not being intentionally biased, but it's reflecting its training data. The effect would be to perpetuate past policy priorities as if they were neutral case management, and that might not be the case. I would say another universal concern might be judicial accountability. As immigration judges, we're accountable for every decision that we make, and we can't, assign uh, that responsibility off to a law clerk's memo or a computer recommendation. And I think accountability keeps judges careful and thoughtful. AI must not diffuse that accountability, and judges should not become rubber stamps for algorithmic outputs. Judges should use that same authority with the AI. So, for example, if AI is integrated, AI might suggest that a certain type of case should take 2 hours. But a judge who sees a person, hears their story, understands a legal nuance, should have the final authority without constantly having to justify independent judgment. This is not happening, and that wasn't happening in um, when I was on the bench. But I'm saying if AI is implemented, these are considerations that should not be disregarded. Again, automation bias is something that I believe needs to be addressed. Research has shown that humans over rely on computer recommendations. The system should require judges to actively choose to accept AI recommendations, not override defaults. And again, an AI tool, if used by the courts, my hope would be that there would be clear ways to track how that AI was used and understand how it was used to reach conclusions, so that a proper appeal can be made. If you don't know how AI reached a conclusion, you can't challenge it and you can't appeal it, and you can't identify bias. So in an immigration case, such as where stakes are, somebody's deportation from the United States or separation from their family, we need to be able to explain um, how the decisions were being influenced and what systems were used to make those decisions. Briefly, I can say unique immigration courts have a unique challenge. I think different administrations may have vastly different priorities, but courts, even administrative courts, have to always remain fair, objective, and independent, and not advance political agendas. And I think in the context of AI implementation, transparency is really key here. Without transparency about how AI systems are designed or deployed, there's a risk that political considerations could be embedded intentionally or unintentionally into the tools that judges use. I would give an example in the scheduling context. If certain cases are prioritized by case types based on policy rather than legal merit, that could have an impact. Systems trained during one policy area that carry those priorities forward into another might have implications. And again, I'm not suggesting this is happening, but without transparency, we can't know. And uncertainty in these processes undermines public trust. I would like to see rigorous discussions taking place, just as they are with other federal courts and respected experts in the field.
One thing you keyed into is to call it a tool. And I love that you called it that, and talking about not or forcing judges to make the final decision rather than to be a rubber stamp for an algorithm. And I think that's great. And as we're kind of coming to the latter part or to the close, I wanted to ask if either of you had the authority to implement one systemic reform that would improve efficiency and effectiveness in the administrative courts, or specifically in immigration courts, what would that specific implementation be?
So I don't think this is going to surprise anyone, but I would make the immigration courts an independent judiciary. That can be done one of two ways: as an Article 1 court or as an Article 3 court, with Article 1 being a little bit more feasible because it's a lighter court and it's easier to enact by Congress. But then Article 3 has the full force of constitutional protections that I believe an immigration court requires. So you're kind of balancing practicality with full protections, but either of those would be a vast improvement on the court system. It would ensure tenure and protection from political pressure for judges. It would give us independent budgeting and more control over how we use our funds. We would have our precedent developed by real courts and real judges, not by the Attorney General or the Board of Immigration Appeals, which is part of the same Department of Justice. And we would have greater transparency and consistency in outcomes, which Judge Chamberlin discussed. We need to rethink independence. It's not as something that's optional. It's not a luxury. It's a precondition for fairness. And it is especially important in the immigration court system where the stakes are so high. The immigration court system has been described very aptly by Dana Marks, one of our former immigration judges and leaders, as death penalty cases in a traffic court setting. And I feel like that description has always stayed with me because it just is so reflective of the problems in the system. So we really need to be continuing to push for an independent court system. And I think so many of these other smaller problems and challenges, which are rooted in that big structural flaw, would also be resolved by this one reform.
I second what you've said, Judge Petit. And again, the theme here today is AI and how to help immigration judges and the courts without harming due process. And creating that independence will do that. We know the problems. It is time that we have, and we know we can more efficiently address the solutions as an independent body in that regard. I think the challenges are different than they were when this current structure was established. And so everybody who works within the court system is committed to reducing those backlogs, creating efficiencies, and most importantly, ensuring due process. And that strengthens all of our court system.
So I usually would give my guests a crystal ball and ask them what they see coming in the next 6 to 12 months. And we all know nothing's going to change with immigration, right? Nothing ever does. Um, as we're looking at due process and we're looking at AI, what do you think over the next 12 months might change or that we should be looking at in that realm?
So I'm not the greatest optimist for due process in this administration, unfortunately. I think sadly things are going to get a lot worse before they get better. But what we need to remind ourselves is that due process is a constitutional protection. That constitutional protection cannot be undone by anyone in the White House or anyone who's employed by the White House. And so, to the immigration judges who I know are there and are still there, who are seeking to ensure due process in every case that's before them and are maintaining that constitutional protection, my faith is in them to uphold that due process that is supposed to be a part of the system, despite challenges from leadership that are trying to erode that.
And with all things being said, do you guys have anything else that you'd want our listeners to know about the current state of due process, AI, and immigration?
I would like the administrative courts to follow the lead of the other federal courts. And I've heard great discussions, robust discussions about the use of AI and tools, and protecting against some of the concerns, for example, with bias, and ensuring that it's used effectively. I would love to see more of that in the administrative courts, in the immigration courts. I would like to see support of that, support for that. I would like to see more trainings for judges to be able to effectively use AI and to be in touch with a lot of what's happening already. I've heard your podcasts and interviews with magistrate judges and preeminent experts and other judges in the Fifth Circuit and the Ninth Circuit throughout the country, and I think that's very inspiring. I would like to see more of my colleagues, our former colleagues, engaged in those conversations.
Well, thank you both for your time. Like I said before, I know that there's a lot going on in the area of immigration, and it's going to be important that we keep in mind as technologies do come upon us that due process is going to be very important, and it's at the cornerstone of what we're looking to do within the immigration court.
Thank you so much.
Thank you.
I'd like to thank Judge Chamberlin, Judge Petit, and Rabihah for their time today. Courts in general are facing case crunches, and for immigration law, you can seemingly increase those challenges exponentially. But as the judges noted, there are ways to reform the system, whether through technology, increased resources, or other means. And as always, the end goal remains increased access to justice for all. Thank you as always for joining us for Clarity on Tech, powered by the Thomson Reuters Institute. You can follow or subscribe to this podcast on your favorite podcast platform, and don't forget to share with your colleagues and leave a 5-star review. For more data-driven analysis of today's professional services market and in-depth conversations with industry thought leaders, please visit us online at thomsonreuters.com/institute and follow us on LinkedIn under the Thomson Reuters Institute. Clarity on Tech is a production of Thomson Reuters, copyright Thomson Reuters 2025.